Going to reconvene the council session. Mr. City Attorney, is there a closed session report?
Thank you, Mr. Mayor. The City Council met in closed session to discuss the matters that were listed on our open session agenda for discussion in closed session. No reportable action was taken.
Thank you. The first item on the agenda today is an appeal of the hearing officer's denial of use permits and reasonable accommodations related to the Yellowstone Women's First Step House. Mr. City Attorney, is there a staff report?
Thank you, Mr. Mayor. Yes, there's a staff presentation. Let me open the staff presentation briefly and then allow our planning staff and special counsel to come forward. As you know, the City Council is hearing an appeal on 4 different facilities, and I'll allow staff to explain them. There are use permit and reasonable accommodation issues. All the matters have been heard by the hearing officer, and he has issued a decision on each one of the issues. There was a modification or amendment of the requests that came to us November 27th from Mr. Poland, the attorney for Yellowstone, and that's part of the discussion that will occur tonight. The standards to be applied by the council in this scenario is the very same standard that you apply in every other appeal from a hearing officer decision for these types of applications. It's an issue of substantial evidence. The question becomes, does the modification request or the modification of the application change, and whether the substantial evidence supports the conclusion of the hearing officer in the face of the modified request that Mr. Poland sent to us on the 27th. That's also before you, and you can expect it to be argued by Mr. Poland. Unless there's questions from the council, this is just like the ones that you've heard before, and I would turn it over to staff to hear the matter, to present to you. Please understand that you're acting in a quasi-judicial manner tonight, and we need to be sure that everyone has a fair opportunity to speak, but the presentations can be managed. If you give the applicant appellant the opportunity to present first, then all the testimony from the public, allow the applicant appellant in order to respond to the testimony that occurred, and staff will close. Thank you.
Is that the extent of the staff report, Mr. City Attorney?
That's the extent of my portion of it. Then I would turn it over to the planning staff.
Okay, and so everyone's clear, we are in our public hearing. Thank you.
Thank you. Good evening, Mr. Mayor and members of the council. I'm Janet Johnson-Brown with the Planning Department. Yellowstone operates unlicensed residential care facilities providing a sober living environment in 4 single-family homes in the West Santa Ana Heights area of Newport Beach. This area was annexed into the city effective January 1, 2008, and is within the Santa Ana Heights Specific Plan District. The properties where the homes are located are designated for single-family residential use. The facilities provide a total of 65 resident beds in the 4 homes, which are located at 1561 Indus Street, 1621 Indus Street, 1571 Pegasus Street, and 20172 Redlands Drive. According to the applicant, the use of the homes as residential care facilities was established between 2003 and 2007, when the area was unincorporated and within the jurisdiction of the County of Orange. The homes were still in operation as residential care facilities as of the effective date of ordinance number 2008-05 on February 22, 2008. Per the requirements of the ordinance, Yellowstone submitted applications for a use permit for each of the locations within the required time period, requesting to allow the continued operations of the facilities. On that same date, they also applied for a general reasonable accommodation for each facility, but did not specify any exemption from a particular city rule, policy, or practice. Yellowstone later submitted an amended request for 3 specific accommodations at a later time. On February 20, 2009, a public hearing was conducted by Hearing Officer Thomas Allen on the matter of the use permit applications. At the conclusion of the hearing officer concurred with staff's recommendation to deny the use permits for the facilities located at 1561 Indus Street and 1571 Pegasus Street, and to approve with conditions use permits for the facilities located at 1621 Indus and 20172 Redlands Drive for a maximum of 15 residents each. The hearing officer directed staff to prepare resolutions and continued the hearing to March 12th to allow the adoption of the resolutions and take action on the request for the reasonable accommodation. At the March 12th hearing, staff recommended that the hearing officer reopen the public hearing on the matter of the use permits to take additional testimony. Staff made this request because during the February 20th public hearing, Yellowstone's legal counsel presented a substantial amount of information on the history of California courts' treatment of legal nonconforming uses, and they appear to assert that they had vested rights as a nonconforming use that should excuse them from having to apply for a use permit. The hearing officer agreed to staff's request to reopen the public hearing on the matter of Yellowstone's use permit application. Per section 20.91A.020, persons whose property located in a residential district was rendered nonconforming by the adoption of ordinance number 2008-05 were qualified to seek a use permit to continue use in the current location. The determination of a nonconforming use is established in section 20.62.030 of the Municipal Code, which states that a use that was lawfully established under the laws in place at that time, but that no longer conforms to the regulations or required conditions for the district in which it is located because of annexation, shall be deemed to be a nonconforming use. However, that section goes on to state that a use shall not be considered to have been lawfully established and maintained, and is an illegal use if it was established or operated without required permits and license, including permits and license required by any federal, state, or local governmental agency. Between the February and March public hearings, staff conducted further investigation into the circumstances and laws in place at the time the Yellowstone facilities were established and while they were under the jurisdiction of the County of Orange. We were advised by the county planning staff that the uses would have been classified as either a community care facility or a congregate care facility, and that both uses for allowing 7 to 12 residents would be permitted with a use permit issued by the Orange County Planning Commission. Our research with the county planning staff revealed that the only property with any type of use permit was 1621 Indus Street, which was granted a temporary use permit in 2005 to hold meetings on site. There was no record of any other use permit issued by the Orange County Planning Commission for any of the other 4 properties. The hearing officer determined that the use of the dwellings as sober living facilities were not lawfully established when they were annexed into the city, and therefore they were not qualified to seek a use permit to continue the use. He therefore directed staff to prepare a resolution of denial on all 4 properties and adopted the resolutions on April 14, 2008. At the March 12th hearing, the hearing officer conducted a public hearing for Yellowstone's reasonable accommodation request. The specific reasonable accommodation requests submitted by Yellowstone were that the residents of each facility be treated as a single housekeeping unit. They requested an exemption from occupancy restrictions under 20.91A.050, which requires that use permits granted to residential care facilities limit the occupancy to 2 persons per bedroom plus 1 additional resident. And they requested an exemption from the city's requirement that all use permit applications be accompanied by a filing fee. The hearing officer was asked to consider only requests number 1 and 3 because without a use permit, request number 2 was not required in staff's opinion, and the hearing officer did not disagree. In order for the hearing officer to approve a request for reasonable accommodation, he or she must make all of 5 required findings. Even if one of the 5 findings cannot be made, the hearing officer must deny the request. In the case of request number 1, that the residents of the facility be treated as a single housekeeping unit, the hearing officer determined that findings number 2 and number 4 could not be made. The hearing officer directed staff to prepare resolutions for denial for request number 1 for each of the homes, which were adopted on April 14, 2009. While staff recommended denial of request number 3 to be exempted from the requirements of a filing fee based on limited, non-verifiable information submitted by the applicant, the hearing officer did not take action. Instead, he directed Yellowstone to submit any financial information they chose within 1 week of the hearing date. However, Yellowstone did not submit any further information. As of this date, the use permit application fees remain unpaid, and no determination has been made on this issue. Yellowstone filed appeals on the hearing officer's decision to the City Council on April 27, 2009, stating as the basis for the appeals that the homes operate such that the required findings for a use permit or a reasonable accommodation can be made. Therefore, the city improperly denied the request. As indicated in the staff reports, staff believes there is substantial evidence in the record to support the hearing officer's decision to deny the applications. As Mr. Hunt noted, following distribution of the staff report for the December 2nd meeting, the applicant's legal counsel submitted an amended request dated November 27th, which was received by the city on November 30th, stating that Yellowstone was amending its request for reasonable accommodation. That amended request and staff's response was distributed to you in the supplemental packet. And Ms. Wolcott from the Office of the City Attorney will describe the details of the request and the amended request to you at this time. That concludes my presentation, and unless you have any questions, I'd like to turn the podium over to Ms. Wolcott.
Good evening. As Ms. Brown stated, we received a letter from Mr. Poland, who is the new counsel for Yellowstone Recovery, and he requested a number of, the way, as he characterized, amended reasonable accommodation requests. We have analyzed the requests. Some of them appear to be amendments. Some of them appear to be brand new requests that we have not seen before. The first one is the reasonable accommodation that will allow it to maintain a maximum occupancy of 12 residents at each of the 4 Yellowstone facilities. Switch to page there. Yellowstone did not phrase its request exactly this way in 2008 and 2009 when we were first looking at this issue. However, this is consistent with what they were asking for in their use permit requests, and it's consistent with the aim of where they were trying to get with their reasonable accommodation requests. Furthermore, there is evidence in the record that would allow the council to make a determination on whether to modify the hearing officer's decision or sustain or overturn it on this particular issue. On appeal, a party may change the legal theory that he relied on at trial, so long as the new theory presents a question of law to be applied to the undisputed facts of the record. So as you consider this new, amended request, you will be thinking about the facts that are in the record below, not any new evidence or arguments that may be presented this evening. We reviewed the reasonable accommodation request in light of the evidence in the record and determined that if the council finds this evidence persuasive, there is evidence in the record that would allow the council to make to modify the hearing officer's denial of the use permits of reasonable accommodations to grant an accommodation for a maximum of 2 facilities with the new reduced bed counts. As you're aware, as you probably heard already in past presentations, government entities are required to make reasonable accommodations from their usual rules, policies, and practices if the exception is necessary in order to afford a disabled individual an equal opportunity to use and enjoy a dwelling, and if the request is reasonable. There is no legal requirement that we grant a request that is unreasonable. Reasonableness is defined under case law as either, an unreasonable request would be one that either creates an undue administrative or financial burden for the city, and in most cases we find that the requests do not, or a request that would fundamentally alter the nature of a city scheme, or city zoning program, or any city program that's being addressed by the requirement. One of the ways that courts have described a fundamental alteration in a scheme is whether or not granting the request would undermine the basic purpose that the requirement was put in place to achieve in the first place. So that's one of the most important considerations that we look at when we're analyzing reasonable accommodation requests. So looking at the revised request for 12 individuals at each facility, we look at whether or not granting at any number or no numbers would be reasonable or would undermine a requirement of the zoning program. In the February 20th staff report, as you were aware, staff had recommended initially that 2 use permits be granted for 2 of the facilities, and staff had selected the facilities that were located the farthest apart from geographically, with a reduced bed count. That recommendation, and the hearing officer initially, when he reviewed it, had been inclined to grant that the use permits for those 2 facilities. That recommendation changed when we found that no evidence had been presented that the facilities had been established under the proper requirements of the county when it was under the jurisdiction of the county. Other than the method of establishment under county jurisdiction, the findings for the 2 facilities at a reduced bed count could still be made with the conditions that the city would have applied under a use permit. And we can still make that finding that other than the method of establishment with proper conditions, the findings that the municipal code requires could be made for 2 facilities at 12 residents each. And if the council were to go in this direction, staff would recommend 1571 Pegasus, both because it is an Oxford house and because it has the only proven valid fire clearance from the Orange County Fire Authority. And the other one we would consider was 1621 Indus, because that is the farthest away from the 1571 Pegasus facility. Reduces the overconcentration. Moving to necessity. The evidence of necessity would be in the evidence that was presented to the city on the sliding scale ability to pay low fee aspect of this facility. We are aware that this is a fairly unique facility within the city as far as the fees that are charged and the sliding scale availability. If you look at Bates number 00720, cost analysis for our homes in Santa Ana Heights, they state in general their weekly fees are based on a sliding scale from $50 to $160 per week. Bates 00728 was an excerpt from the Yellowstone webpage where it states that Yellowstone Recovery charges $160 to $180 per week. And if you've reviewed the staff report, you're also aware that there was some back and forth between staff and opposing counsel on the different numbers that were reported. And the opposing counsel stated that the lower number that they were quoting was based on their ability to actually collect from some of their residents and the ability that they were actually able to charge that amount. So that ends, unless you have more questions, and you may later, about that first request, that ends the staff's analysis of that request. The next one that they asked us to consider was that the city treat each of the houses as a single housekeeping unit by waiving the requirements that all the residents be on a single written lease. We have analyzed this a lot in the past. A single housekeeping unit, the requirement of a single housekeeping unit that's adopted in our municipal code is a crucial definition, not just for dealing with residential care facilities and disabled housing, but for dealing with illegal dwelling units, for dealing with illegal boarding houses. We feel very strongly that we need to protect and defend the integrity of our single housekeeping unit definition and not undermine it in any way. Any group that is living as a single housekeeping unit within the city of Newport Beach is able to reside as a single housekeeping unit anywhere without any of the restrictions that we would place on them under ordinance number 2008-05. Whether they're related, unrelated, disabled, non-disabled, if they're a single housekeeping unit, they can live anywhere in the city. And that is the breadth of the request that the applicant is asking for, whether they realize the breadth of it or not. If we granted an accommodation that allowed them to be treated as a single housekeeping unit, none of the reasonable restrictions that we are placing to mitigate the adverse secondary effects on the neighbors could be applied. And we feel it's very important to keep that. Furthermore, the ordinance has already effectively granted a reasonable accommodation to disabled individuals. There is no other group of no other group that is not living as a single housekeeping unit that is allowed to live within the city. All other non-single housekeeping units are banned in every residential zone in the city, and therefore the ordinance automatically grants an accommodation to disabled individuals. There are still other requirements, but that accommodation exists. Furthermore, treating them as a single housekeeping unit is a broader exemption than is necessary, and so it fails the necessity analysis as well as the reasonableness analysis. There are many other accommodations that they can request that would enable disabled individuals to live within the city, and they have potentially made one this evening. Therefore, we would encourage and recommend that the council sustain the hearing officer's decision in this area. The applicant requested that the city grandfather the fire clearances that it has claims to have received from the Orange County Fire Authority prior to the city's annexation. The city has already agreed to grant this. We have told Yellowstone's council that if they can provide us with evidence that they did receive valid, non-conditional fire clearances from the Orange County Fire Authority prior to annexation, we will accept them. Of the 4 facilities, they have provided us with evidence that one of them, 1571 Pegasus, received a fire clearance from the Orange County Fire Authority. The other clearances that were presented either were conditioned upon making certain changes and corrections, which we have no evidence were made, or just a list of corrections in the case of Redlands, the corrections that needed to be made, and no evidence that they were made, no evidence that a Form 850 was ever completed. And in the case of 1561 Indus, I don't believe we received anything. So we still stand ready to receive any evidence from the applicant or from the fire authority that those clearances were given for any other than 1571 Pegasus, but we have not received them to date. They also request that the city apply all of its building, zoning, fire, and life safety codes to each of the houses in the same manner that we apply them to single-family uses or single housekeeping units. As far as applying the zoning codes in the same manner as we would apply to single housekeeping units, we've already addressed that in their request to be treated as a single housekeeping unit. It's essentially the same request. As far as the building and fire and life safety codes, this is a new request. There was nothing that was raised before the hearing officer that creates any evidence in the record that would allow you to make a determination on this in the opinion of staff. However, if you decide that there is evidence, I would urge you to consider that we do not recommend granting exemptions that reduce the life safety for disabled individuals. We feel that being up to code with life safety issues and fire safety issues is something that's very important with disabled individuals of any type, and that the applicant ought to be embracing those additional controls and not trying to get out of installing them. Okay, is there another one? And finally, they request a waiver of the occupancy limitation of 2 per bedroom plus 1 to determine the maximum occupancy. There was no ruling by the hearing officer on this particular request because it was determined that it wasn't necessary to grant it because there were no use permits granted. This was only relevant if a use permit were granted because the 2 per bedroom plus 1 restriction is an operating restriction. That's part of the use permit requirement, not any other part. However, in the case of the homes that they are asking for exemptions from this evening, all of them except 1561 Indus are 6-bedroom facilities. So at 6 bedrooms, they don't need this exemption anyway. They already can meet that standard. The only one that would need the exemption would be the 5-bedroom 1561 Indus. Under those restrictions, it can only house 11. They're asking for 12, but that's not one of the facilities that we would be recommending granting. Are there any questions? Thank you.
May I invite the appellant to come to the podium, please? Mr. Poland?
Thank you. Thank you, members.
Will 15 minutes be sufficient for your comments, sir?
I hope so.
Okay, very good. Please introduce yourself for the record and
My
welcome
name
to
is-
Newport Beach.
My name is Stephen Poland. I'm counsel for the appellant Yellowstone. First, I would like to thank the city council for bearing with me while I was ill and continuing this hearing. And I'm very happy to be in a warmer climate than in Washington, D.C. Let me work backwards here. couple of things at play, and let me deal with this concept of reasonable accommodation. And we certainly disagree with the city's position and the city's analysis of how reasonable accommodation plays out here. The analysis for reasonable accommodation that the courts have adopted is, one, is they take a look to see if the request is reasonable. If the request is a reasonable accommodation, then the burden shifts to the city to either demonstrate that it's either an undue burden financially or administratively, or that would fundamentally alter some scheme. In this case would be the city's zoning code. Then, if it's not, if it doesn't meet any of these criteria, then the courts look to see whether it's necessary. Now, the city, Ms. Walcott and the city seem to be putting all of its eggs in the basket that it's necessary in terms of finances, and we disagree with that. Our request for reasonable accommodation is necessary because it's therapeutically beneficial that we have, in this particular request, groups of 12 living together. It's been our experience, or my experience, or my client's experience, that recovery from alcoholism and drug addiction works better when there are numbers up in the area of 12, and that's partly for several reasons, and this was highlighted in my letter. One is that loneliness is an addict's and alcoholic's worst enemy. So if you have 12 people living in the house, there's a likelihood that someone will be there at all hours of the day. People newly in recovery often have difficult times dealing with issues that you and I take for granted. Rejection, a bad day at work, boss getting on somebody, girlfriend, boyfriend issues, financial issues. And to come back to a safe and sober place and be able to talk to somebody about these issues rather than going out and using or getting alcohol or getting drugs, it has been found that merely by talking about these issues relieves the obsession to drink. Talking about concepts of recovery, talking about how to be able to integrate concepts of recovery in everyday life and to deal with everyday problems has been found to be beneficial when there are numbers such as 12. The other thing is that usually people share bedrooms in sober houses such as Yellowstone, and that's because people can keep an eye on each other, and also it combats this issue of loneliness. And if someone relapses, it's important for the other people in the house to know that someone has relapsed, because keeping secrets such as relapsing infects the entire house in terms of being able to keep secrets, in terms of being able to sort of co-sign this type of behavior, and that if I let this slide, maybe they'll let it slide for me. So the therapeutic benefit is the necessity prong that we emphasize. And the courts have said that when you look at whether it's necessary to have, in this case, 12 unrelated people living together, will that number ameliorate the effects of alcoholism and drug addiction? Or in other words, will it enhance the recovery process? And it's pretty much universal. I wouldn't say universal, but we would be able to establish, probably to a degree of certainty or in terms of substantial evidence, that yes, there is amelioration. There is a beneficial aspect to the issues of recovery when you have numbers of 12. Now, financial necessity is also an issue, but it's not the prime issue. Numbers of 12 are needed because you have people who are newly in recovery, who are trying to get back into the workforce, who are trying to become responsible, productive members of society. And there are two things at play here. One is the ability of the resident to pay the rent. The other is the ability of the housing provider, Yellowstone, to pay the bills. So courts have said, yes, it is permissible in terms of financial necessity to allow providers such as Yellowstone to be able to make money in order to pay the bills to provide this type of housing. Now, we disagree with the notion that your ordinance builds in an accommodation for disabled people. There are way too many hurdles and obstacles to overcome to say that this ordinance somehow or another benefits disabled people. The important thing about reasonable accommodation, which the city glosses over, is that it only applies to disabled people. It does not apply to non-disabled people. It does not apply to other protected classes under the Fair Housing Act. So it doesn't apply on the basis of race. It doesn't apply on the basis of national origin. It doesn't apply on the basis of religion. It only applies to groups of disabled people. Congress specifically put in to the Fair Housing Act this concept of reasonable accommodation because they realized that there were obstacles being placed in the way of groups of disabled people to get the type of housing and the type of neighborhoods that are needed without being tied up in hearings in state court and having negative appeals taken against them. Let me address a couple other issues. One has to do with this annexation issue that Mr. Allen found that there was substantial evidence that Yellowstone was operating illegally in the county. The county, and found that there was substantial evidence to support this. First of all, this is based on an exchange of emails between Mr. Kiff and somebody in Orange County. I don't know what this person's title is, where Mr. Kiff posed a hypothetical, basically, and said, yes, if this is true, then this is what we would have classified Yellowstone as, and this is what they would have needed to comply. I would submit to you that positing a hypothetical question or a what-if question and receiving an answer does not constitute substantial evidence. I would also posit to you that what the city and what the hearing officer did was place Yellowstone in the position of proving a negative or disproving a negative. So the city's position is they were operating illegally in the county, therefore we don't have to grandfather them in. We don't have to give them the benefit of our ordinance under the annexation agreement. The problem with this analysis and the problem and the reason why it does not meet the standard of substantial evidence is the flip side of the coin here is that the county took no action against Yellowstone. The county knew about Yellowstone. The county knew that Yellowstone was operating. And there's nothing in the record that the county ever initiated any enforcement action against Yellowstone. There's nothing in the record that the county ever issued notices of violation against Yellowstone. So the city position is that we have deemed Yellowstone to be in violation of county ordinances because they did not obtain a permit. Therefore, they are an illegal, non-conforming use, and they don't get the benefit of the ordinance of being annexed and being treated as a legal, non-conforming use. That is not substantial evidence. That's merely a legal position. It's a legal position that denied Yellowstone any modicum of due process, of an ability to challenge this, and it was, for all intents and purposes, a fiat accompli. It just said, this is how we're going to treat the Yellowstone. We're not going to give them the benefit of the staff report, and we're going to recommend the denial of their request. And this is wrong. This is wrong. Now, there are a couple other things I want to talk about. One is this notion of single housekeeping unit and granting the reasonable accommodation would somehow or another cause a fundamental alteration in your zoning scheme. Now, everyone is aware that the city of Newport Beach spent a lot of time and a lot of money exploring options in terms of coming up with a regulatory scheme as it pertains to group homes. We know that Judge Selna said that your definition of single housekeeping unit is facially neutral. We also know that in order to get around Adamson, that the city put in a requirement that all the residents of a single housekeeping unit has to be on the same lease. Now, reasonable accommodation means waiving a policy, a rule, a procedure that is facially neutral. So waiving this unitary lease requirement, waiving other portions or making an exception for other portions of the definition of single housekeeping unit would not fundamentally undermine your zoning scheme, because it would be granting Yellowstone the opportunity to be treated as a single housekeeping unit, which many courts across the country, in facing similar group home issues, have said that group homes for recovering addicts and alcoholics, when the reasonable accommodation request is made, is to be treated as a family. And I have participated over the years in many zoning hearings and in many instances of municipalities that say, well, how can a group of recovering addicts and alcoholics be a family? You know, you don't have a father, you don't have a mother, you know, there are no children, you know, who makes the decisions? And this is a common theme in the Oxford House cases, where Oxford houses are democratically run and where you have a president and a treasurer, and they say, well, how could a president be a head of household? And the courts have said that's not the analysis. The analysis is how does the group function? And the group functions similarly to a family, and they have family values. And the courts have basically said that in these kind of instances, waiving a requirement of the number of unrelated people is a reasonable accommodation for sober living arrangements such as Yellowstone. Well, we don't have, and it's still legal in the state of California, to limit the definition of family based on numbers. So you have the single housekeeping unit model. And I would submit to you that there is no fundamental alteration other than the fact that by denying the reasonable accommodation, the city would be denying this group of recovering addicts and alcoholics the opportunity to live in the neighborhood and the housing of their choices. The other issue that Ms. Walcott brought up has to do with, well, it's of no importance that we impose these heightened fire restrictions, because they should welcome the imposition of these fire restrictions. There's a case called Marbrunick versus the City of Stowe, Ohio, which stands for the proposition that when you're dealing with groups of disabled persons, you have to take into account the nature of the disability and their ability to respond to emergencies before uniformly applying life safety restrictions. So in this instance, when we are requesting that Yellowstone be treated as a single-family use for the purpose of all code requirements, we're serious. They're capable of responding to fire emergencies just like any other group of related people living together. They would have smoke alarms, CO2 detectors, fire extinguishers, that type of thing. The other dynamic that has changed.
Mr. Poland, you've gone to 15 minutes. I'll let you continue a little bit, but we are...
Very good. Is that all of the Yellowstone houses are now chartered by Oxford House. Oxford houses are self-run, self-supported housing for recovering addicts and alcoholics. They're democratically run, they're financially self-supported, and they kick out anybody who relapses immediately. There's no staff, there's no house managers. The residents make the decisions, including who's going to live there. And if someone should relapse, or someone doesn't pay the rent, or someone engages in disruptive behavior, by a vote of the majority of the residents, they could be asked to leave. That wraps it up. Thank you.
Thank you, Mr. Pollard. Any questions?
Yes. You've asked for 4 units with 12 each, and you made a point that the number 12 is important because of the loneliness and everything. This is a little confusing to me because you have a curfew, and for certain hours, they're not to be there. But after a certain hour, they're all supposed to be there. So it seems to me that with a curfew like that, whether you had 4 people or 12 people, there's going to be somebody there because you have a curfew and everybody's supposed to be home by that time. Is that, am I misreading that?
Well, those are what the Yellowstone rules are. Now that these houses are chartered by Oxford House, those rules may change. There may be changes in the rules as to the emphasis in an Oxford House is that everybody should work. Oxford House has learned over the years that not everybody is able to work because of other disabilities and that type of thing. So the emphasis is on Oxford House wants people engaged in some sort of productive activity during the day, whether it be actually holding a job, whether it be volunteering, or whether it was as commonly as called in AA and NA, engaging in service work. It is preferable that people do not sit around the house during the day doing nothing. It is preferable that people come home and are in bed at a reasonable hour. It is preferable that the people who live in Oxford houses or any other sober house do not engage in any kind of disruptive behavior that's going to disrupt the neighborhood, so to speak. So while Yellowstone has those rules may change. I'm not going to tell you that they are. But the basic concept is that people should be doing something constructive during the day. If they're home at night, then they're home at night. Now, whether a curfew remains, I don't know, but at the same time, we don't want people coming in at all hours of the night either.
Well, I guess, yeah, I don't want to hang you up on words, because I know when you're standing there speaking, a lot of times you'll use one word and perhaps I'm, again, misinterpreting. But you say it would be preferable if they didn't disrupt. It would be preferable if they didn't. And it seems to me that we've got some contradictions here, because if you're trying to get certain behaviors and it's only preferable, then are you saying that it's acceptable?
No. People who engage in disruptive behavior aren't welcome to live in the house.
So it's not preferable, it's a rule?
It's a rule.
All right, well, that's what I wanted to clarify, because when you say preferable, to me, it means we've got a choice of whether we're going to do it or not.
People who engage in disruptive behavior, either in the house or disrupt the fabric or the continuity of life in the neighborhood, aren't welcome, because they're not living a life of recovery. They're not doing what is expected in terms of becoming or striving to become a responsible, productive member of society. You know,
I just wanted that clarification, so you clarified that I took the word either too seriously, I guess. Thank you.
Are there any other questions for Mr. Poland?
Just one quick one. At what point were these 4 homes actually certified as Oxford House?
So
I assume there's some piece of paper that shows that.
well, I don't have it, but the 1621 Indus and the Redlands House were just chartered last week. They just received their charter last week from Oxford House. The other 2 houses, I think, have been chartered from the onset of these proceedings. They were chartered at the time of the use permit applications. They were chartered at the time of the hearings last year, at the 2 hearings that were conducted last year before Mr. Allen.
Okay. Thank you, Mr. Poland. We'll give you an opportunity to come back and sum up. We're now going to open it up for comments from the audience. How many people would like to speak on this matter? Very good. If you'd just come to the podium then. We have no more than 5 minutes of comment per person. Please try and be succinct out of courtesy to the other people who would like to speak as well. So we're now open for public comment. Thank you. And please state your name from the podium so that we get that for the record as well. Thank you. And
my name is Stephen Abraham. I'm a resident at 1592 Pegasus. I live across from one of the homes, one of the 4 in the neighborhood. Before I came to this hearing, I was disturbed at a number of things that I and other neighbors had noted. I will tell you that having sat here this evening, I have far greater concerns than I came with, and will probably have far greater numbers of questions when I go home and speak with the neighbors. The first is that, as had been submitted in a letter that I previously directed to the city, these homes were represented as being 3 for women and 1 for men, when in fact that was not fundamentally true. With respect to the home at 1571 across from my home, it was both men and women at some point. Moreover, as was noted by counsel on behalf of the appellant, rather contrary to some of the comments that have been made, the statement was made, and it was suggested that it was being asked to prove a negative, that is, to prove that it was, in fact, not lawfully permitted. In fact, this is nothing more than the same arguments that we have heard for years with respect to these homes. That is, just because we weren't prosecuted, we weren't cited for something, that means that we were lawful. That means we were permitted. I was at the hearing when they said we were a lawful use, we were a permitted use, when that, in fact, wasn't the case. Throughout these hearings, in the many years that the city has dealt with it, or the county has dealt with it, during the entire course of this application and now the appeals, what we've essentially heard from the applicant has been the equivalent of what would you like the answer to be. That is, notwithstanding the fact that there is a fundamental change in their particular use at any time, the city is asked to review their application not on the basis of what appears within the community, not what appears within the neighborhood, and not the way they act, but rather with the equivalent of the question, how would you like us on paper to appear? How would you like us to be in the neighborhood? Something very far removed from reality. With respect to the claim that these are 6-bedroom homes, most of the homes in that tract are 4 bedrooms on the second story, 1 bedroom on the den on the first. That's 5 bedrooms no matter how you slice it. And yet they come here and tell you that 12 not only is not a sufficient number, but they would like to be relieved of that obligation. But as I began, I said I was very concerned about some of the things that I was told. When the city regulates the ability of anybody to operate something other than a single-family residence, it has the ability to place conditions on them. When this was a Yellowstone operation, which apparently it was before every hearing until tonight we learned that it really isn't, and these are really Oxford homes, we at least were told that there were certain rules that would be put in place. The individuals would not be there during the day. Now we're told, well, there are guidelines, there are suggestions. This is self-regulating. Quite frankly, it's far beyond self-regulating because what the appellant is asking for is the ability to avoid all of the restrictions or any restrictions the city could impose upon them, essentially to create an enclave with at least 4 homes, the rules of which, or the rules applied to which, are whatever we, the residents, feel they ought to be. I'm disturbed because this isn't merely something that none of us would have the luxury of being able to do, but would fundamentally alter, what the hearing officer said, would fundamentally alter, if not destroy, the very essence, let alone the character of the neighborhood. They've asked for a lawless situation, and I think the hearing officer was right in denying the application and the appeal. So should the city council. Thank you.
thank you. Next speaker.
Good evening. I'm Chet Grosskreutz. I live at 1551 Pegasus Street in Newport Beach. And besides just saying amen to everything Stephen just said, I would like to just focus on a couple points. I've lived there for 30 years in the same home. And you know, I'd like to draw an analogy. I heard counsel make the point that because the County of Orange did not act on any violation, that it was somehow a problem and that they would be automatically grandfathered. You know, I could drive 65 miles an hour down Newport Boulevard, and if I guess I wouldn't get a ticket from a Newport Beach police officer that I really didn't go 65 miles an hour. But it still doesn't change the fact that, you know, I can travel 65 miles an hour in a 35-mile-an-hour zone and still break the law, just not get caught. And so that premise, I think, is patently false. It doesn't hold any water in my mind. It just doesn't make any common sense. And then the second thing I'd like to just speak to that I heard counsel mention about the Alcoholics Anonymous and some of the statement he made about groups. My father was an alcoholic for 45 years. He was very active as a leader in Alcoholics Anonymous in Costa Mesa and ran and was a director of the Charles Street location in Costa Mesa. And as a young man and a child, I had many alcoholics in my home during holidays. My father was a leader. I mean, I saw all of those men recover, and they didn't do it with 12 or 10 or 6. They did it with one sponsor who was at their side all the time. And that's the premise of Alcoholics Anonymous. It is not, and it should not be, pretending here to mirror that image. I take kind of an exception at that, because I think the best, from my experience firsthand, the best action that my dad did was one-on-one. And sure, there were meetings. They were once a week, but day in and day out, it was one-on-one, peer involvement, not necessarily with 10 or 12 or 15 residents. So from my perspective, I don't see any reason at all why anything should be given, any accommodation of any kind should be given to the Yellowstone or Orchard or whatever they are now, for any reason. The hearing officer was accurate. I've sat through these same meetings for the last several meetings and listened to the same thing, and it just appears to me that the conditions and the rules by this group and council seem to be changing. Every time I come to one of these meetings, I hear something different than I did before. And I don't think that the regulations and the ordinance that I read, that the City of Newport Beach, which, by the way, I thank you very much for, I believe that you've spent enormous amount of hours researching this and trying to be fair and equitable to all the parties involved, including those recovery homes, which do have, I believe, a very easy group of conditions to follow, just like we as residents. I wouldn't expect that fire codes would be eliminated in my home or my street for any other reason. I mean, I would expect to be in compliance with all of the codes, whether they be permits, which we know there are no evidence from the county that permits were given, whether it be fire code, staff has not found any proof. I mean, if they have those things, then they should be able to provide them. If they don't, then they don't. It's very clear in my mind. I guess my main point here is that I want to reiterate, I do agree with the hearing officer, and I would strongly encourage the council to concur with his decision and not grant any accommodations to this group. Thank you very much.
Thank you. Next speaker, please.
It's Mike McDonough, 1562 Pegasus Street. I live across from the 1571 Pegasus. I just have a couple of quick comments. Yellowstone, the organization, and now I guess it's Oxford, every time we've had one of these hearings, they've come in and stated what their rules are, what the people aren't allowed to do, what they are allowed to do. And it's all been ignored by the residents. There's been observations time and time again that they violated the rules that they said they had established. From parking to intermingling from the different houses to men and women living in the facilities, all of that, their council said was not going on. Well, it was going on. The residents across the street from me now, the 1571, there are 2 people living there now. The majority of them have moved out, And these two individuals had said they had purchased the house from Yellowstone, and Yellowstone no longer owned it. So either Yellowstone is not representing themselves accurately tonight, or the people that are living there did not in fact buy the property as they indicated. As for residents being able to vote someone out, what's to help us if they get 6 people in there that are disruptive? They don't have a majority. They can do whatever they want. The city, if we give them reasonable accommodation and waive the regulations, nothing's to prevent the group from voting to do whatever they want. They don't have to evict anybody. They don't have to limit disruptive behavior. You've given them the right to do that. I ask the council not to grant this permit. Thank you.
Thank you. Next speaker, please.
Larry Mathena, M-A-T-H-E-N-A. Just briefly, frankly, of all the locations where we've had these issues to deal with, this is probably the most intense, the one that, frankly, I would struggle most if I was a neighbor there, and struggle with the one that I am stuck next door to me with. But just one thing I'd like to reiterate is what I've heard, evidently, is that Yellowstone has surrendered its control over its facilities to Oxford House, Inc., a charter organization, and I guess I'd begin with asking, do we have the right applicant at all at this point in time, given what's changed, number one. Number two, who would be the party to enforce, even under reasonable accommodation, whatever circumstances that the rules that were still applicable would be in effect. And last but not least, it sounds like to me that Yellowstone has slid into the position, I guess, of an absentee landlord. And again, the basic premise of someone making an application for the use of the facility is that they're responsible. What I've heard said so far is that responsibility has totally been abrogated to, and forgive me for putting it this way, but it works, to the inmates. And to get to the point that was stressed earlier, the inmates can be very, very happy but not complying with the rules at all relative to the community. And I think, if anything, the factual data you've been presented to in this hearing, to me, is strongly undermined whatever case that the applicant may have walked in with.
Next speaker.
I'm Barry Walker, 1571 Indus Street. By the address, obviously, we have a house next door to us, and another house a few blocks, another house about 5 houses up. iHome office, my office window looks right out the front of 1561, and 1621 is there. I'm an architect. I'm there probably 60-70% of the day. I see what's going on. Excuse me. The one that we found interesting over the last several months is the occupancy on these houses has drifted down to 2, 3, maybe 4 sometimes. And yet we're led to believe that they need 12 people to make this work. Well, their houses aren't working well right now if they only have 2 people in there or 3 people in there. There's, the question of, were they ever granted a use permit? Did they ever apply for one? We've been there for 22 years. For a use permit at the county, because I've processed them through the county, there's always a public hearing. There's public noticing. Never has been anything on it, so I can answer that question for them. They go, we don't, how can we prove something that's a negative at the county? And Dave Kiff just kind of gave them a what-if scenario. Well, I've been living there. There's been no notification of a use permit request. The other one that's really getting me is that the fire department regulation and reviewing the homes for suitability. We've got, right now 2, 3, 4 people living there. The cigarette butt barrage in our front yard, has lessened substantially from what it was a year ago. But if they were allowed to have 12 people there, I can see why we want the fire department to be there. In all of the other homes in our neighborhood, we're talking about 2 parents, maybe a third adult, so 2 or 3 people smoking in a house. Here we've got the probability of 12 people smoking in a house. Raises the percentage probability, of somebody smoking in bed and lighting that place up. So, yeah, you get more people, more possibility for a fire. They need to be checked out, and that hasn't happened either. The last one was the Yellowstone gave us all the rules at one of the meetings. There will never be any vans that we use for moving our clients from one place to another. Those will never be parked in your neighborhood. Most of the time, let's say 60% of the time, there's at least one, and on most weekends, both of the vans they use parked at the Redlands house all weekend. One in the driveway, one in the street. So, we've learned over time that Redlands rules don't mean anything. Be in by 10, be out of the house by 8, out of the house by 8 o'clock, everything is gone. At about 9 o'clock, a couple of people drift back in, and their cars are parked in the driveway all day. Well, that rule's being upheld real well, but it's, like they said, a democracy, and if the House Mother President isn't there, they don't know it. There's nobody comes by to check on these houses that's from Yellowstone to ensure that their rules and policies are being carried forth. That's got mine. Thank you very much.
Judy Walker, 1571 Indus. I just want to go on public record to substantiate what the neighbors have said. Yellowstone, while they have told us as owners of property in that neighborhood that there are rules that their houses will abide by, we have heard and proved time and time again, there's plenty of evidence been entered into testimony, that Yellowstone as a managing group is not watching over their facilities. Disturbingly tonight, we've heard that now those managing abilities are going to be lessened even more, that these are going to be Oxford charters, and they're going to be self-governed. I ask the council to consider that the whole goal of the purpose of these use permits is to keep the fabric of an R1 situation residential. These are to be homes and residences. We've heard testimony from council that 12 people in a facility means they can come home from a bad day at work and talk and work things out. What happens to me who comes home from a bad day at work and has to listen to 12 people arguing all hours of the night and going on and on? The concentration that you're asking our neighborhood to put up with is ruining the fabric of the fact that we are a residential neighborhood. The individuals in these facilities are not permanent. They have no tie to this neighborhood. It is only a situation for them. They have no desire to be part or care about the neighborhood. And I ask the council to please keep that in mind as you consider the issues before you this evening. Thank you.
Are there any further speakers? All right, seeing none, Mr. Pola, may I invite you back for 5 minutes of closing statements?
Thank you. A couple of things. Oxford House model is an extremely successful model. There are 1,400 Oxford houses across the country, all based on the same principle of being self-run, self-supported, democratically run, financially self-supported, and kicking people out. If you want to call it the inmates running the asylum, then maybe it's the inmates running the asylum, but they do it very successfully because they take what they do extremely seriously. I've heard the complaints of the neighbors. I've heard the concerns of the neighbors. Look, any household on any given night, tempers are bound to run a little hot. It's the nature of family-type living, and if there's arguments having at one of the houses, then there are arguments at one of the houses. However, they get resolved successfully. I will tell you that Yellowstone has not abrogated any of its responsibilities with these houses. Yellowstone has made a decision that in terms of having staff, in terms of giving the residents more responsibility, that the Oxford House model is an appropriate model to have. It does not mean that Yellowstone is washing its hands of these houses. It does not mean that Yellowstone is not going to be involved in these houses. That's far from the truth. Yellowstone takes a great deal of pride in what it has done. I just talked to Mr. Zafati. I asked him a question because the neighbors keep making this point about the presence in Orange County. Mr. Zafati handled these hearings before Mr. Allen. He did a great deal of research into the annexation and about the existence of Yellowstone while it was in the unincorporated portion of Santa Ana Heights. His research indicated that there weren't any complaints from the neighbors about the Yellowstone houses. It seems that your hearings and your requirements have now brought these issues out, whereas these issues didn't exist before. One other thing I wanted to state about these fire clearances, which I forgot to mention the first time around. Ms. Walcott mentioned, and it's true, that Yellowstone was invited to bring to the city any applications, any correspondence that it had with the county concerning the fire clearances. Yellowstone took Ms. Walcott and the city up on that offer and went to Orange County to obtain copies of their applications and dealings with the county on the fire code issue. As it turns out, that file was given to the city of Newport Beach, and Yellowstone doesn't have access to it. So we're more than willing to discuss with the city this issue, but we need access to the file. Thank you.
Thank you, Mr. Poland. With that, we'll close the testimony. May I ask the city attorney, do you have any comments relative to the testimony that's received?
Thank you, Mr. Mayor. Yes, just a couple comments, and then I would like to let staff address anything that came up during the public hearing. First of all, of course, the council knows that we're here to balance the interests that exist, or the council to balance the interests that exist between the applicants and the neighborhood as a whole. The council has repeatedly handled these matters and has acted consistent with the Federal Fair Housing Act in addressing the issues and treating people with disability fairly. I understand Mr. Mathena's metaphor. The council has never used it, and I would just like to say, well, I understand that the actual use of it, it's certainly not consistent with the way the city has approached any of these issues. With respect to the question of whether or not we're trying to disprove a negative, I respectfully disagree with Mr. Poland. We expect everyone who's issued a permit from the city to have a permit. And yes, we would, of course, turn it over to them if they asked. I'm not aware of the file being sent over to our fire department. But I can say from review of the record and review of the different documents involved that they've only given us one permit that's actually been certified for by the Orange County Fire Authority. That having been said, staff has repeatedly told them should the information surface, and we've given them multiple opportunities to do so, we would certainly take that into account, and in fact, our fire marshal has indicated any valid certification from Orange County Fire Authority would be honored by the city of Newport Beach, and staff stands by that position. And just one last cautionary note for the council, as you're quite aware, we're here tonight for you to address the question of whether or not substantial evidence exists in the record for the hearing officer's determination, basically as the determination was presented by the hearing officer, and or if there's a modification or amendment, that if there's evidence in the record to support an amendment or the hearing officer's decision in relation to that amendment. Anything said here tonight is not evidence. If it doesn't exist in the record, it's as if it did not happen. It is only argument. Argument is to be taken as a reference to evidence in the record, and you may take into account evidence in the record, but not argument, except for how it might sway you on its persuasiveness. That being said, so the two new certifications as Oxford House, as far as I can tell, could not possibly be in the record, and I certainly didn't see it when I reviewed the record. So that's not evidence that can be taken into account to determine whether or not the hearing officer was correct in his actual determination. For that matter, any testimony by the residents, as much as we might be sympathetic to their concerns, that does not appear in the record, is not something that may be the basis of your decision tonight. With that qualification, I would like to ask staff if there's anything they'd like to address from the presentation. Pardon? Yeah.
Sorry,
Can
we have one moment? Just so we don't repeat each other.
I could talk longer. Oh, yeah, one last, my apologies. And this is, my role is to advise you with respect to evidentiary issues and not to advocate, and I'm not advocating. The issue of substantial evidence is a tricky one, and I appreciate Mr. Pullen's statement. I have to respectfully disagree with it. However, by definition, staff's testimony and its analysis is substantial evidence. He may disagree with it, but it's substantial evidence. So the hypothetical that was posed by Mr. Kiff, if that's the way it came forward, is in fact substantial evidence with the response from the county, and in fact, it's my understanding staff performed an independent analysis of the issue as well. That's what the substantial evidence plays out in that context.
Thank you.
2 quick points.
Please identify yourself for the record.
I'm sorry, Kip Bobko, I'm special counsel for the city. 2 quick points. The first one is with regard to the necessity prong. As you recall, counsel for the applicant said that there was a financial prong and then there was a therapeutic prong. Again, dovetailing with what your city attorney just advised you, it's a good thing they're not counting on the financial prong because there are no facts in your record to support that. The only facts regarding finances had to do with the permit fees, as you recall. And if you'll rewind your memory tapes back to the last time we were here doing this, there was a remand to the hearing officer regarding the financial viability. So as in that case, the same applies in this case. You don't have any facts before you in the record to make that determination, so I don't think you should even consider that. With regard to the therapeutic benefit of having more people in a home, I am unaware of any evidence in the record where that argument was specifically made below. Moreover, I don't think that that's necessarily important because the legislature has already weighed in on that and said that 6 people is the number that is the magic number. As you're all aware, 6 and below, we have no authority to regulate. So I don't think that there is anything, and nor is there any evidence in the record to support 12 as opposed to 16 as opposed to 18. And in fact, if you are inclined to grant reasonable accommodation, having said all that, staff recommends that you do grant the 2 homes with 12 each, which was, if you're inclined to go that direction. The last thing, and again, your city attorney has beaten me to the punch, counsel for the applicant said that there was a series of what-if hypotheticals posed to the Orange County Planning Department about whether or not certain permits had been applied for and granted, and that does not constitute substantial evidence. We respectfully disagree. That does constitute substantial evidence. If staff went and did an investigation and then sat here and provided that testimony to the hearing officer, that could very well be substantial evidence. And in fact, in this case, the applicant was unable to produce the documents that were requested. And so the only evidence in the record was staff's investigation and the information that staff communicated to the hearing officer. And that certainly constitutes substantial evidence. Last thing, with regard to the Oxford homes, this is the first time we've heard of that this evening. I think it is an important element of probably to take into consideration because Oxford House, as a franchise, I don't know what the proper term is, but as an entity is, I'm sorry? As an umbrella organization, thank you, is a well-known organization with it's well-known. It is a well-known organization. Having said that, this is brand new testimony this evening, which is not in the record, nor was that in the record before the hearing officer. So while it is important, I would caution the council to take that too much into consideration, if at all, because that is not something that was before the hearing officer. And again, tonight you are not allowed to hear new evidence that was not presented to the hearing officer. I'm happy to answer any questions if you have any.
Are there any questions for Mr. Balco? Thank you,
Very
Kent.
good.
I'm going
Thank
to bring this back to the council then for any council questions or comments from staff or comments or a motion relative to the item.
I just had a question for the city attorney. This issue of Oxford House, not Oxford House, really I think what we're being asked to make a judgment on is not what might have happened in the last week or two or what might prospectively happen because they could be chartered or certified as Oxford House. We have to read the record of what was before us in the past. That is in the record, whether or not they were Oxford House, we still have to be guided by the evidence in the record about how these homes were conducted and the various adverse impacts that might have been associated with them. Is that correct?
That is correct. You're reviewing the record and seeing if the record supports the hearing officer's determination. And on the issue of Oxford House, just briefly and quickly, because it goes to the single housekeeping unit issue, Mr. Poland used the word family a number of times, and please understand, as the council, I believe, knows, and I would like the audience to understand, the council in the city does not make a determination on whether this is a single family. It's a question of whether it's a single housekeeping unit which functions like a family. So the council in the city of Newport Beach does not discriminate against people with respect to their family ties or status. And that's not how our ordinance is drafted, nor has it been the basis of any of your prior decisions. So thank you.
Thank you. Any other comments? Councilmember Daigle.
Yes, question for the city attorney. Is the record sufficient to sustain the decision of the hearing officer?
I believe so. I've reviewed the record, council member, and it's my opinion, at least, that it's sufficient. Of course, that's a determination that the council is making. And you certainly are exercising independent discretion. And I know that you've had this for some time, and I'm comfortable having spoken with you that you've reviewed the documents involved. So please feel free to ask me any questions you have on that topic. I do believe, at least from my analysis of it, the evidence is sufficient, but you could disagree with me.
Okay, well, I would make a motion to sustain the decision of the hearing officer. If there's a second or...
I'll second that.
Okay, thank you. And members can discuss around the motion. And I certainly appreciate that the majority of the council recently took the time to visit this neighborhood, so we're all familiar with the neighborhood and we're all watching over you. And we know that when you came into the city that things were lax with the county, but we have made every effort to retain the single-family character of your neighborhood. And we recently have been engaged in a lawsuit to secure the single-family residential character. We've also provided increased levels of police protection with a new fire station. We believe it's a more safe community. So I just wanted to let you know that the entire council really wants to retain the character of your neighborhood, the single-family residential character.
Councilmember Gardner.
I was particularly interested since I did not sit through the hearings, but I did read the transcripts, and I have found nothing that would tell me that I should substitute my own judgment in place of what the hearing officer found. I found substantial evidence to support his findings, so I will support the motion.
Mayor Pro Tem Henn.
Well, I did sit through the hearings, I think every one of them, and also reviewed the material in front of us and would concur that the record is replete with support for the reasonableness of the hearing officer's decision, and so I'll support the motion as well.
Any other council members wish to make any comments? The motion before us is to sustain the findings of the hearing officer and to deny the appeal. All in favor, please vote.
Motion carries unanimously.
Thank you. We're
Just for the record, too, it's my understanding that we'll be bringing back resolutions that will confirm your findings for your adoption, I believe, at the next council meeting, God willing, and if the creeks don't rise. I'm sorry, the 26th.
Thank you. Public comment, Madam City Clerk?
Public comments are invited on non-agenda items generally considered to be within the subject matter jurisdiction of the council. Speakers must limit comments to 3 minutes. Before speaking, please state your name for the record.
Is there anyone who wishes to make additional public comments at this time? Seeing none, public comments are closed, and we